The United States government maintains a massive, highly formalized architecture designed to oversee housing equity. The administrative state pours millions of hours into monitoring the rental market. Federal officials consistently champion extensive policy frameworks in these hearing rooms, drafting guidelines intended to stabilize vulnerable communities and prevent illegal evictions. Look at the programs they've built on paper. You have HUD's Eviction Protection Grant Program, designed to intercede on behalf of tenants. You have the Legal Services Corporation channeling millions through basic field grants to fund local legal aid. And underlying all of it is the bedrock of federal housing law, the Fair Housing Act. But the LSC itself tracks the functional reality of this entire apparatus. They call it the justice gap, a metric showing exactly how many low-income Americans receive inadequate or zero legal help for essential civil problems. A formalized apparatus for housing equity is a structural illusion if that massive bureaucracy cannot physically place an attorney next to a tenant in a local courtroom. When you move from the federal capital to the specific jurisdictional reality of Louisiana, that gap becomes the defining feature of the legal system. Inside a Louisiana eviction docket, the vast majority of tenants arrive to face highly complex civil proceedings entirely unrepresented. They stand alone against opposing counsel. Because of this imbalance, the courtroom ceases to function as a place of nuanced legal inquiry. The momentum shifts into a relentless, mechanized process where volume takes precedence over the specifics of any single case. In these rooms, if a tenant does not have legal counsel to raise those federal mandates we just listed, protections like the Fair Housing Act effectively do not exist. The absence of representation means the Louisiana Housing Court functions as a streamlined processing plant for systemic dispossession. We can see exactly how this procedural imbalance plays out by looking at this legal ledger, providing a direct comparison of how the court enforces statutes. On the left, we look at the strict enforcement of state codes favoring property continuity for landlords. The court strictly applies statutes like Louisiana Civil Code 2725. If a lease contract contains an option to extend, the law dictates the lease continues for the term and under the other provisions stipulated in the option. Local courts rigorously parse these exact words, enforcing every letter to protect the landlord's financial interests. Now we pivot to the opposing side of the docket, the legal mechanisms meant to shield the tenant. First, you have the mandatory 30-day eviction notice requirement, a basic procedural safeguard. Below that, you have federal civil rights overlays, including defenses under the Fair Housing Act. But during an actual hearing, these tenant protections are routinely ignored by the bench. They fade out of the proceeding completely. The bench ignores them because the tenant lacks the specialized legal counsel required to formally enter these complex defenses into the court record. When one set of laws is strictly enforced and the other is erased, the court operates as a unilateral enforcement arm for landlords. To understand why those tenants are standing alone, we have to trace the funding back to its origin at the federal level and watch where the system breaks down. The Legal Services Corporation is the primary mechanism for funding local aid. They distribute capital through basic field grants, allocations meant to pay for legal representation in local districts.
Look at the intended flow of this federal money on this flowchart. It starts as a massive appropriation at the top, meant to cascade smoothly down into state-level civil representation. But as those funds move through bureaucratic pipelines, there is a severe structural drop-off. State distribution nodes create immediate bottlenecks, filtering the resources down to a trickle. The LSC is fully aware of this attrition. They explicitly track the varying local legal landscapes using tools like their eviction laws database. Yet the ultimate point of failure remains. A funded program on paper fails to translate into a physical attorney deployed inside the courtroom. Federal appropriations mean absolutely nothing if bureaucratic bottlenecks prevent that capital from materializing as adversarial friction in a state courthouse. That friction is a requirement. In our legal system, substantive rights do not self-execute. This brings up sua sponte, a Latin term meaning of one's own accord. It refers to a judge taking action without a prior motion. A judge will almost never intervene sua sponte to apply a Fair Housing Act defense. If the defendant does not raise the specific legal argument, the judge will not make it. We can map a proper procedural architecture of a hearing using this logic tree. An eviction filing splits into two potential pathways: rigorous due process defenses or an immediate leap to summary judgment. Surviving the docket requires hitting specific procedural steps. You have to demand proof of the 30-day notice or formally invoke the FHA. Activating these due process pathways requires defense counsel to physically enter the argument into the record. When the reality of the Louisiana justice gap removes that attorney from the equation, the model collapses. Without the attorney node, all due process pathways become inaccessible dead ends. The procedure bypasses scrutiny entirely and drops straight to dispossession. The legal system relies entirely on two opposing sides testing the evidence. That makes the physical presence of counsel the non-negotiable prerequisite for civil justice. Moving from the abstract procedural model back to the physical reality of Louisiana shows the true scale of the damage. This map visualizes the cumulative scale of the crisis. Across Louisiana's jurisdictions, thousands of individual eviction filings hit the docket every year. When we filter this data to isolate the individuals forced to face this machinery alone, the map turns overwhelmingly red. The federal bureaucracy labels this concentration of red the justice gap. Processing tens of thousands of unrepresented evictions at this scale results in the industrial-level rubber stamping of illegal dispossessions. When the courtroom doors close on an unrepresented tenant, the legal system reaches a point of absolute finality. When a court prioritizes processing speed over a tenant's right to representation, it forfeits its legitimacy as an adjudicatory body. Accountability will not happen organically. The bench will not spontaneously correct a system that favors its own efficiency. Accountability must be forced onto the judicial system. We must target structural reform. We have to demand that state judiciaries rigorously enforce statutory compliance from landlords before a single eviction order is signed. Support the Louisiana Housing Reform Task Force in their mandate to establish a universal right to counsel. Ensure the Fair Housing Act is strictly enforced in every courtroom, not systemically ignored.